Today, let's talk about buy-sell agreements for attorneys. Why you need one, what are some of the benefits, and what are some of the common mistakes that we see in these agreements? First of all, what exactly is a buy-sell agreement? Few attorneys are surprised at what a buy-sell agreement is, but I think it makes sense for us to take a few minutes and review what they do, what they are. A buy-sell agreement at its very basic form is an agreement between multiple owners in a single law firm. Ideally, it outlines how an attorney will sell their stake in a law firm before they need to sell their stake in a law firm. This should define the steps that we take, whether an attorney dies, whether they get disabled, they get divorced. We want to know what are the next steps in buying out their shares of the firm. This protects the remaining shareholders from an angry ex-spouse or a disability lawsuit or something of that nature. The remaining business owners know exactly what the next steps are into buying out the business. And they've got it all detailed out, written ideally, for anybody that comes saying, hey, there is a mistake here. It also ensures that the departing party's assets are protected. The person, when departing due to death, disability, retirement, whatever it is, they know what the value of their asset is when they leave. This is especially important for heirs because as non-attorneys, we all know that heirs can't own shares. Oh, that rhymes. That's perfect. Heirs can't own shares. You need to protect those shares and the value of those shares before you exit the business. Without a buy-sell agreement, co-owners are often worried about, well, what happens if somebody wants to leave? It creates tension. It creates uncertainty. But what's worse is the co-owners that don't think about it, the ones that don't have that uncertainty, the ones that don't have that stress. Because what typically happens is someone eventually exits the business and they don't know what to do next. And that definitely creates stress, uncertainty, and concern. One of the first mistakes I see attorneys make is that they are terrible at updating their buy-sell agreements, which isn't horribly surprising. As a financial advisor, the last person I help with their investments is me. So attorneys, not surprisingly, are guilty of the same thing. They essentially write the agreement or have someone else write it, and then they forget about it. Ideally, you have someone else write it, by the way. In that same vein, I often see stock agreements that are written after a buy-sell agreement or a buy-sell agreement written after a stock agreement's written. The two agreements forget to reference each other. They start to get conflated. They're mixed. Someone exits, both contracts are used for different purposes, and suddenly there's a whole bunch of mishmash. There's uncertainty again. There's stress again. So make sure that agreements agree with one another. Often, if you have a stock agreement, you don't need the buy-sell and vice versa. So make sure that you have the one that best fits your situation. However, today we're just talking about buy-sells. Let's get back to that. We want to make sure that we have one agreement specifically because sometimes people come back and disagree with what's going on. And if you have two agreements, suddenly there's a fight and you have to trust in an attorney, a set of attorneys or a judge to determine which party you are and who deserves what. So why is this a mistake? Well, I mean, obviously it creates a huge mess, but there's some more. What may be less obvious is that contracts age. As contracts age, a lot of firms that I've come across have fixed values on the buyout. So in the past, I've actually come back to a law firm and said, hey, your buyout says that your company's worth $100,000. Actually, in this case, it was $700,000. And I came in and said, I'd like to buy your firm. Now, of course, I was being facetious. I'm not an attorney. But in this particular case, all the attorneys in the room said, no, we would never sell our business for $700,000, except if any one of them had passed away. That's exactly what they would have had to buy the firm from. That would be the basis for buying out the shares from the deceased or departed party. So you have to be asking yourself, am I okay if I was to depart right now and receive the value that it says I should receive in the buy-sell agreement we have? And if you're not okay, that's a good reason to update it. So final note here, every 5 years, review your buy-sell agreement. And if needed, update it. When was the last time you updated that buy-sell or reviewed it? Has it been in the last 5 years? Well, regardless, in that same vein, the second mistake I see is that often attorneys don't create an agreement that can grow with them and their firm. More specifically, you need to record events as they occur, remembering that they can affect the future. So, silly example, if someone retires and the shares are purchased, You need to document the purchase and make sure you have an addendum with your agreement showing that those shares were purchased and paid for. We've seen situations where a partner retires and passes away, and the family comes back and says, "Hey, did you ever pay us for those shares?" Well, you better have documentation showing that you did. Sure, you can probably go back and maybe you can look at bank statements, but you're putting a lot of trust in that ability. You'd be much better off having the agreement signed and documented showing that the shares were indeed paid for and that funds were transferred to the estate. And there's countless other examples just like that. Exits, new people joining the firm, divorce, disability, retirement. We all know that different things can occur, and we want to make sure that we're prepared for them. So, lesson 2, make sure the agreement grows with the firm. This goes back to lesson 1 as well. Every 5 years, we should be reviewing that agreement, making sure that the agreement grows along with the firm and is updated appropriately. Also, don't forget, last note, you may need to wrap up that agreement. You may need to shut it down and start a new one, or maybe the firm is just done and you're renaming it, and so a new agreement's required. Make sure that you document that that plan was wrapped up and is no longer in effect. And the third mistake is about taxes. We want to make sure that you keep all the money that you deserve for selling the firm to someone else. So how can we use a buy-sell agreement for that purpose? You can use a buy-sell agreement to transition the practice from one generation to the next. And this is an ideal thing to do if you have a long period of time. Even better, it's all perfectly legit. The IRS, well, we can't say the IRS is behind it, but the IRS isn't against it at this point. However, so often when I meet attorneys, they want to retire in the next year or two. I want to encourage you not to procrastinate this decision. Make sure that you are on it far before that point. I love to see people come in with a decade to go. But let's put this in perspective with some kind of an example. Let's say you have a junior attorney. We'll call him Tim. Tim eventually wants to take over your business. Let's just say Tim earns $500,000 a year in fees. Instead of paying him $500,000 in fees, you're going to give him his cut less a contribution to your defined benefit plan. So Tim will get his portion less a specific contribution that goes into your defined benefit plan. So why would Tim contribute to your retirement? Well, it's pretty simple. Tim is going to begin buying out your practice by giving you payments into your defined benefit plan. The reason you want to take the benefits early is that you can get paid over time and defer those taxes as well over time. What's also in it for a senior partner is typically they can get the highest payout from an existing partner. An existing partner has time, even a junior partner has time to transfer the most important thing in your business. Relationships. So you get a max payout, you get deferral of taxes, and your junior advisor, Tim, he gets a trusted business, relationships, something that is solid and will continue. The reason buyouts in law practices are so lean is that everyone recognizes relationships are key. An outside third party coming in and buying the firm is going to lose a number of those relationships with the loss of key partners. But a junior advisor can get the most benefit out of those relationships because the relationships can be transitioned over time, hence maximizing what they can pay the existing partners. However, as we all recognize, any junior advisor, Tim in this case, needs to earn that trust, needs to earn those relationships with the people that you already work with. So the buy-sell agreement allows Tim to see what he will receive over time and allows you to get the max payout and also keep the most amount of money by deferring taxes. This is why we like longer time frames. The longer you have, the better the tax deferral is, and the more time that Tim has to transition relationships and to earn the trust of the people that you already work with. If you don't give yourself enough time, you eliminate your ability to defer taxes, and you also put Tim in a crunch because now he has to quickly transition those relationships and earn that trust in a time frame that may not be reasonable and certainly won't maximize the value that both of you will get from the transaction if you both have more time. So those are the 3 points I wanted to cover about buy-sell agreements with you today. I encourage you to, 1, get an agreement in place, a buy-sell, a stock agreement, get something in place today and review it regularly. I would say every 5 years, and make sure everything is relevant and still up to date. 2, make sure it grows with you. Add to the document as people in your firm change or their or your circumstances change. And finally, 3, take advantage of the tax benefits you can gain by utilizing your junior partners. You both maximize the value of the transaction, you get to defer tax, and you get to maintain the reputation of the firm you built for the younger generation. Most of the attorneys I work with know that they should have a buy-sell agreement, or they know that they should update it. But typically, a lot of the agreements we see are limited in scope, like covering themselves in case of just death. And the point is, you can use these agreements for so much more if you just take some time to plan it out. Well, I hope this has been useful, but keep watching and I'll see you next time.